Today, Mr. Scott Farley, who is a specialist in Canada in cross-border litigation. He also is a specialist in international law arbitration, and he has, among his many degrees, both master's and doctoral degrees in law. And with him today is one of his associates, Rusbeh Husseini, who will also contribute. And we are also extremely fortunate that Professor Brand has agreed to participate in the program as well. As some of you may know, Professor Brand was and is the U.S. negotiator in Hague Convention, on the Hague Convention on the recognition and enforcement of foreign judgments, and has so much to tell us about that. This is a topic that both of my classes will be looking at, maybe from slightly different angles. So this will be, I think, an extremely interesting preview of what we will be looking at in weeks to come. And because of how pressed we are for time in this program, I'm just going to turn the floor over. I will mention to the speakers, you do not need to attach the mic. The mic is strong.
Okay. Okay. Do you care if I give a little bit of introduction?
Please go.
Okay. I'm gonna. When you get as old as I am, one of the nice things is that they let you invite friends to come visit, and so that's kind of what is happening here. Scott Farley is really one of the leading Canadian lawyers in the area of international litigation. He studied at Queen's University, got his BA in LLB, but then did an LLM at New York University and SJD at Harvard. He's done a whole lot of things. He's been Canadian Bar Association National Section Chair for both constitutional law and international law, the past president of the Canadian Council on International Law, which for those of you who are familiar is kind of the counterpart to the American Society of International Law. Does a lot of international litigation, international arbitration. He and I worked together, I guess it's been a while now, but for in The Hague, at the Hague Conference on Private International Law. He was with the Canadian delegation, I was with the US delegation when we completed the Hague Convention on Choice of Court Agreements. There's now a new convention being negotiated, scheduled for diplomatic conference this summer, the Hague Convention on recognition and enforcement of foreign judgments. And this is an area in which Scott is really one of, if not the leading Canadian lawyers on it. He has with him his associate, Rusbeh Husseini, who has his JD from Michigan State University, but studied in both the U.S. and Canadian system, LLB from Ottawa, and also had a Bachelor of Science from the University of Toronto. Okay. So, but also works in the area of international litigation and international commercial arbitration. So we're going to let them do their thing here. Their flight from Toronto was delayed this morning, but they made it on time. But nonetheless, they're going to have to leave right at 1:30, and then you're going to have to put up with me for a few minutes. So at 1:30, we're going to let them go off to their flight, and I will take it up.
Come up at the same time, yeah. Thanks very much, Ron. Appreciate the opportunity to speak to you today. The subject of public policy as a kind of a focus for the discussion today came out of Ron's involvement as co-rapporteur with a professor in Geneva whose name eludes me, but the International Association for Procedural Law. And he's doing a worldwide survey of the role of public policy in as a component in recognizing and enforcing judgments from foreign jurisdictions or not. And I thought that was an interesting subject, if only from the point of view that public policy defenses from a practitioner's perspective, and certainly in the civil context, are few and far between. The arguments are raised sometimes, but by and large, not so much. And why is that? Between jurisdictions, like most state jurisdictions here and provincial jurisdictions in Canada, there is a general consensus of norms between the systems of law that evaluate one another in the cross-border context. And where there's a consensus around those norms, things like due process, notice, all those things that you study in civil procedure, there's not a lot to object to from a public policy standpoint. However, sometimes there's glitches. And I will return to those after Roosbeh gives you a snapshot of the basic principles under which a Canadian court will recognize and enforce a foreign judgment. You'll hear a lot of things that are familiar, some of things which are not, and time permitting, he'll talk about some of the novel interim remedies we have that you don't in that context. And then I'll come back at the end to the public policy defense before we're whisked out of here, and Ron can make sense of what sense about what we said.
So it's 20 minutes, I think?
Yeah.
Okay, all right. I apologize if I speak quickly. If you're not comprehending what I'm saying, just let me know, and I'm going to slow down. Our time is very constrained. So what I'm first going to do is compliment you, because flattery is always good. And I'm going to compliment you because I think studying U.S. law and under the U.S. Constitution, I think sometimes one doesn't perceive just how U.S. law has diverged from other common law jurisdictions and how lucky you are. And one of the principles that you should really appreciate in this jurisdiction is the full faith and credit clause of the Constitution that allows the states within the United States to recognize the judgments of other states. And this was a concept up until not too recently that was foreign to other common law jurisdictions, particularly Canada. We didn't discover this in our law until about 1990. And prior to 1990, our law didn't always recognize the judgments or orders of courts in other provinces. So if you happen to obtain a judgment against a foreign defendant who happened to live in Alberta, and you obtained that judgment in Ontario, and you went to enforce that foreign judgment in Alberta, it wasn't always clear whether the judgment would be enforced. And that's because, based on our law prior to 1990, the courts really looked at jurisdiction with respect to where the defendant resided at the time that the action was commenced. Jurisdiction was focused on the individual. And so if the action commenced while the defendant was residing in the jurisdiction, or if the defendant had returned to the jurisdiction of that foreign court, then the domestic court, where the judgment was being enforced, would be successful. Otherwise, you would have to retry the case from inception, because the court wouldn't recognize the jurisdiction of that other court. So you can imagine if an individual was in Ontario, was a defendant in a action in Ontario, but happened to move from the jurisdiction prior to the action being commenced, you would have to think twice about whether you wanted to commence that action because you may not be able to enforce it. And so there weren't much options prior to 1990, but that all changed with the Supreme Court case of Morguard Investments. And in that case, for the first time, the court recognized the concept of comity between jurisdictions, the respect given between different courts, and the presumption, if I can say it that way, that the court did in fact exercise jurisdiction appropriately unless shown otherwise.
Right.
And so the principle that the court laid down was this concept called the real and substantial connection test. And what the court identified was what one really needs to look at is not just where the person resides at that moment or when the action had commenced, but whether the court that tried the action at first instance had a connection to the subject matter of the action. This was the concept that changed our law in Canada. So, as an example, in Morguard, the case involved a defendant that owned property in Alberta. He didn't pay his mortgage payments, and at the time that a foreclosure action was commenced against that defendant, he had moved to British Columbia. Now, unfortunately, the value of the property didn't make up the amount that was actually owed pursuant to the mortgage. So the mortgagees commenced an action against the defendant to make up the difference between the value of the property and what was owed. All of this took place in Alberta, and all of this took place while the defendant resided in British Columbia. The defendant didn't defend the action, which was typical at the time, because he assumed, and unfortunately wrongly, that the plaintiffs would then have to come to British Columbia and start everything anew. And what the court ultimately found at first instance and at the Court of Appeal, which was then codified for different reasons at the Supreme Court level, was that it's not enough just to look at where the defendant resides. You have to look at whether or not the court at first instance has subject matter jurisdiction, which means, is it the best placed to deal with the issues at hand? And so it was ultimately determined that because the property was in Alberta, it was the Alberta court that was best placed. And arising out of that came the substantial connection test. Now, the problem with the court's decision in Morguard was that while it identified the real and substantial connection test, it didn't tell us really what it was beyond that the real and substantial connection test is something must be between the jurisdiction and the defendant or the subject matter of the action. It didn't elaborate any further. Now, while Morguard dealt with the enforcement of judgments in the domestic context and not in the foreign context, meaning internationally, courts immediately seized upon the Supreme Court's decision in Morguard and began enforcing foreign judgments against Canadian residents. And it wasn't until 2003, so 13 years later, when an appeal from a decision in Ontario, BC, Beals, Beals.
Oh, Ontario.
Ontario.
It's all Ontario,
Yeah.
Florida.
It wasn't until 2003 when the Supreme Court had the opportunity to hear an appeal from a judgment in Ontario enforcing a Florida judgment. And in this case, the plaintiff had obtained a judgment in Florida after purchasing a property from a Canadian. And unfortunately, there were some issues as I understand it, misrepresentation potentially with respect to the property. The plaintiff thought that he was purchasing a certain plot of property that ended up not being it. He couldn't do what he wanted to do with the property, so he ended up suing. Just like in Morgard, the defendants in this case didn't defend the action in Florida on advice of their lawyer, who said, don't worry, they'll get a judgment in Florida and they'll have to retry it here.
He had an out-of-date conflicts book.
And gave wrong advice. So they obtained judgment in Florida and came up north to enforce it in Ontario, and they were successful. And the court in Beals essentially used the real and substantial connection test and gave a nod to Morgard to enforce the Florida judgment. And in doing so, set out a number of defenses that one could rely upon in the event that a foreign judgment is sought to be enforced against a Canadian defendant. One is whether or not the foreign court exercised jurisdiction correctly. And in that context, what the courts do in Ontario, or in Canada I should say, is they apply the real and substantial connection test to the exercise of jurisdiction by the foreign court. And because the real and substantial connection test is so broad, the typical result is that the Canadian courts will find that the foreign court exercised jurisdiction correctly. The next are the impeachment defenses, which are fraud, but fraud on the foreign court. Okay? Not the tort of fraud that's in the subject of the action itself. Was there fraud on the court? But also fraud that wasn't discoverable at the time that the action was tried. Typical example would be if somebody lied, right? And it wasn't discoverable. The public policy defense is the judgment something that could be enforced in Ontario. A perfect example of that would be contempt orders. If you obtain a contempt order against a Canadian defendant in the US, that requires the payment of a fine, any amount. The Canadian court will typically not enforce the contempt order on the basis that, from a public policy perspective, Canadian courts do not enforce the public laws of foreign countries. And then the next example is natural justice. And that's pretty straightforward. Did the person obtain notice by our standards? And then this nebulous basket clause of interest of justice. Now, we had talked about the real and substantial connection test and the fact that it wasn't really defined. That changed somewhat in 2012, although not entirely. But it did change somewhat because the Supreme Court was able to sort of narrow down the application of the real and substantial connection test. And the first thing the Supreme Court said was that there is a presumption that there is a real and substantial connection, which is what we talked about. And that presumption can be rebutted by the party seeking to deny jurisdiction, meaning the defendant, in certain circumstances. But the list of presumptive factors are: did the person reside in the jurisdiction where jurisdiction was exercised? Did the defendant carry on business in that jurisdiction? And I want to stop here briefly because I'm no expert in U.S. law, but as I understand it, U.S. courts will exercise jurisdiction in cases where somebody carries on business, even if it's minor business. Is that right?
That's been changed for general jurisdiction.
It's been
But not
changed.
for specific.
Not for specific.
But if the cause of action arises out of that conduct within the state,
Right.
the answer is yes.
Right.
In this
Right. Okay.
specific jurisdiction.
Right. So if it's a tort, for example, that occurs or something.
So international shoe is still good law, at least in part, right? Okay.
Right. Okay. All right. So the concept is very similar here then. Okay. Conducting business means conducting substantial business. It's not something that's fleeting. However, just as you've described it, if the damage occurs in the jurisdiction, so for example, the tort occurs, so you send a product to Ontario and it catches fire and burns down the house. Because the damage was sustained there, there's a presumption then that the court has jurisdiction. And finally, if the contract connected with the dispute was made in that foreign jurisdiction. Off to you.
Do you want to do the two
we have time?
remedies? I think, yeah, it's 5-2.
Okay, so just briefly then,
This is just Canadian novelties.
yeah, this is a novelty that will that doesn't really deal with what Scott will be talking about, but we thought it'd be interesting to raise two instances where the common law in Canada diverges from what you may be used to. And the first is the concept of Mariva injunctions. A Mariva injunction is a interim remedy, an interlocutory remedy that allows plaintiffs in Canada to freeze the assets of a defendant. It's akin to execution before judgment, which is quite a serious thing. But it's typically used in cases where the defendant is seeking to dissipate assets and move those assets out of the jurisdiction. And it typically arises, though not so much now, but historically, the Mariva injunction remedy arose in cases where the subject of the action was, for example, an airplane or a ship, something that would potentially leave the jurisdiction and likely never return. More and more, the remedy is being used in fraud cases, where somebody steals money, steals property, and there's evidence that that money or property is going to be dissipated. Usually, Mariva injunctions are brought ex parte, In order to succeed on a Mariva injunction, one has to show a prima facie case, show again, like I've indicated, risk that the assets are being moved, and at all times there is a duty to reveal all the facts. That means it's important, it's absolutely important that the plaintiff argue both sides and reveal all the facts, even those facts that may harm the plaintiff. And if one doesn't do that, there is a good chance that the order would be set aside and costs ordered. The other interesting remedy that we have in Canada, which I don't believe you have in the US, is a remedy called an Anton Pillar order. This is a private search and seizure order carried out by the plaintiff against the defendant. And the way this works is that if there is a particular piece of evidence that is required, that is in the possession of the defendant, which is at risk of being destroyed or removed, a court can order that the plaintiff attend at the premises where the property is situated in order to seize the property. Again, one must show a strong prima facie case, potential damage, it must be very serious, and clear evidence of destruction, the possibility of destruction. Now, the way the court does this is it doesn't just allow the plaintiff to attend at the property and walk into somebody's private residence or office and take what he or she wants. What will be ordered in these circumstances is a third-party lawyer will be retained by the plaintiff who acts as the agent for the court. It's called an independent supervising solicitor or lawyer. And that independent lawyer who answers to the court is the one who oversees the search, records the evidence, obtains possession of any evidence, and reports to the court.
And there's the plaintiff's undertaking.
And in both cases, both in Anton Pillar orders and in Mariva injunction cases, the plaintiff has to undertake to the court that it will pay the damages. In some cases, the plaintiff will be required to actually pay that money into court.
Also costs, right?
Yeah, if so, both in both contexts, because the orders are obtained ex parte, as I mentioned with Mariva injunctions, you have to, the duty is on the plaintiff to provide all the facts. If you don't do that, then there's a real risk that the order can be set aside and cost ordered.
Okay. Okay. Stage is set, real and substantial connection. Once that hurdle is over, then it's pretty much clear sailing for the enforcing parties, save and except the impeachment defenses. Real and substantial connection is the jurisdictional test. Okay, did the court have jurisdiction? Was there real substantial connection? Then, even if they did, is there a major screw up that runs contrary to what a Canadian court would think is fair? Fraud on the court, absence of procedural fairness, your procedural due process. Don't get that mixed up with the substantive stuff, which we don't have in Canada and is indulged in here in various jurisdictions, which is essentially a substantive right, not a procedural argument. And then public policy, which is the focus of what we're doing with Ron to explain how it unfolds in Canada. And then there's this basket clause of the interests of justice at the end. And I think recent case law, and I'm going to finish off with a discussion of the Chevron case you've probably heard about on the US side, which is now being litigated in Canada because the litigation has been shut down in the United States. But it is alive and well and living north of the border so far.
Barely.
Although they're running out. It's on close to being life support, but
Yeah.
leave to appeal pending in the Supreme Court of Canada for the second time. The public policy defense has been very narrowly construed. That is to say, it only applies to the substance of a foreign law, not how it's been applied in a procedural context, but the substance of a foreign law that is contrary to Canadian public policy, the law on its face. Example, interesting BC family law case. Nasty little divorce between an Iranian couple who are living in Vancouver. And the husband is a bit of a ne'er-do-well, but the marriage and the marriage contract is all concluded pursuant to Islamic law
In Iran.
in Iran. But they're living in Vancouver, and the property that's issued in the civil case is in a Canadian jurisdiction. It's in British Columbia. So the wife, who's on the short end of the stick, institutes proceedings, and the major defense of the husband is under Islamic law, only he and not she can institute divorce proceedings. The Canadian court looks at that and says, well, guess what? This is Canada, and that's contrary to Canadian public policy. Interesting point, though. The choice of law is Iran. Okay, so Canadian law cuts Iranian law off at the pass in that case. How can it do that? Well, no enforcement powers in Iran. Can't rely on the wife being able to go back to a court in Iran and get a judgment that gets her to where she would have access to her marriage contractual rights in British Columbia. What they do is simply say, okay, you're not entitled to rely on this. We're going to order you to go back to Iran and get your divorce. And in the meantime, we're going to hold on to the property until you sort it out. And she's entitled to that. But it's an interesting, that's where the public policy defense effectively cuts off the foreign law, which would, in the normal course, would normally be the proper law of the illegal arrangements. Okay. Example 2, in the commercial context, and this is a little more interesting one. This is an Ontario Court of Appeal decision for which leave was not granted to the Supreme Court of Canada. Society of Lloyd's Names versus Saunders, 2000 decision of the Ontario Court of Appeal. For those of you who are interested, 2001 Ontario Journal number 3403, 55 OR 3rd, 688. There you had a bunch of Canadian investors who really got slammed on their investments that were the subject of litigation in Britain. And enforcement proceedings were brought in Ontario to collect. The public policy argument brought in the defendant's favor was they sold us these securities contrary to Ontario securities laws. There was no prospectus. There was no application for an exemption from the prospectus. Therefore, we were blindsided. Therefore, these judgments are directly contrary to what the rights these investors would normally have under the law of Ontario. But both the motions judge and the Court of Appeal agree, says, not this so fast. These Canadian investors were members of Lloyd's Names. And so they bought into that system. The English Court of Appeal said the proper law of these contracts was English law, and the normal defenses were addressed before the English courts and disposed of in favor of enforcement. So the doctrine of comity trumps public policy, or as the motions judge said provocatively, Ontario public policy in this case must support comity between nations, which is kind of, it's kind of turning the impeachment defense on its head and making it a ground for enforceability, notwithstanding the law of Ontario would normally say the plaintiffs would be out of luck because they hadn't conformed with Ontario securities law. Okay? So that's where public policy kind of strays into the realm of this amorphous basket clause that Rusbe talked about, the interests of justice defense, which is a fourth category. The Supreme Court of Canada has recognized but not articulated. It was dealt with at first instance in the Beals case, which affirmed Morguard International, even though lower courts applied Morguard to foreign cases in the 13 years that separated the two cases, much to the chagrin of a lot of Canadian defendants. And Ron and I discussed this at length in the context of the Hague about uneven playing fields and all that sort of thing. And here I would go to how public policy can be potentially characterized in a different way than it has been. And here I'm quoting from Justice LaBelle in the Beals case, who wrote the majority judgment. And he says, and I quote, "Public policy is potentially an expansive enough concept to subsume the other two defenses. It is, of course, contrary to public policy in a broad sense to enforce a judgment that was fraudulently obtained." But then he goes on to conclude, but it is useful to maintain the analytical distinction between the three defenses. We do so here. But the interest of justice defense is lying out there, and what I'd like to turn to in the, well, we're not doing badly on the time, is the Chevron case. Now, how many of you, just I'd like to show of hands, how many of you are familiar at all with the Chevron proceedings out of Ecuador that came into the Southern District of New York?
Not bad.
Oh, a few. Okay, that's good. This is a really horrific case. And if you want the Canadian perspective on it, there's a couple of articles that you can get in blogs off our website through LinkedIn where I wrote about it. And there's now, I don't know how many arbitral and court decisions there have been, but we're looking at Ecuador, we're looking at New York, we're looking at arbitration in the Netherlands, and we're looking now at litigation which is still ongoing in Canada. For those of you who don't know about that case, it starts out with Chevron being the unlucky successor or absorber of Texaco, which had an indirect subsidiary operating in Ecuador. And sorry, that's my cell phone. Terrible. Anyway, it'll go away. There was environmental devastation. There was no real clean hands on either side. There was an American lawyer who conducted the litigation in Ecuador, allegedly bribed the judge, wrote the judgment, did all sorts of amazing things, which resulted in a $9.5 billion award. So all sorts of remedies were sought. This lawyer was very enterprising. We come to the Southern District of New York Federal Court, and the judge there, I can't remember his name, but Kaplan. Justice Kaplan says in very clear terms that from, I think, a public policy standpoint in the U.S., and more particularly because of fraud at first instance. This case, and I think due process would apply as well, that it wasn't enforceable. And the Second Circuit basically affirmed Kaplan on point, right? At that stage, Enterprising Counsel in Toronto is approached, and they sue Chevron, the parent, and Chevron, the sub.
In Canada.
In Canada, in Ontario. And the case went to Supreme Court of Canada on Roosbay's point one, jurisdiction. Because the argument was made by Chevron and its sub that Chevron Canada had nothing to do with Chevron US or Chevron subsidiaries in Ecuador or anywhere else. And for those of you who would do a corporate study of the Chevron empire, it's one silo after another that is essentially autonomous, right? So that was their defense. And so they said no jurisdiction to name Chevron Canada at all. Answer eventually at the Supreme Court of Canada, not true. Not true. If there's a presence here, the court has prima facie jurisdiction to look at it. Whether or not you end up with an enforceable, whether or not that decision should be enforced, we will not decide. But the court certainly has jurisdiction to entertain the application. So back we go to the trial level, and then the Court of Appeal, and the answer there is consistent that, by the way, corporate separateness is not only a holy grail of the common law, but it should be enforced. Solomon principle. And so you can't get at the sub through the parent, especially, it's kind of easier going from the sub up, but going from the parent down when there's no connection at all makes absolutely no sense. That issue, that decision, is now awaiting the granting or not of the plaintiff's application for leave to appeal to the Supreme Court of Canada. What's interesting about it for today's topic is the only defense, or the only sort of nexus that the plaintiffs have left under Canadian law is public policy turned on its head in the interests of justice. Okay, notwithstanding what happened in Ecuador, notwithstanding what happened in the United States, which cuts the plaintiffs off from Chevron US. Chevron is Chevron, and you've got all these people in Ecuador who suffered terrible diseases, permanent land damage, blah, 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 blah. Terrible stuff. Go back to my previous comment. No clean hands in this case. You should, in the interests of justice, give these people respite. And by the way, there's a huge pool of money here which can do that. And by the way, there's nowhere else to go. Now that is what is really intriguing about where public policy in Canada, in the quote-unquote interests of justice, may or may not be going. Now I've had chats with counsel from both sides in that case, and they're both equally convinced that they have the right of it. The plaintiffs' team is really interesting. It's a firm called Lenzner Slatt, and senior counsel there is a former Supreme Court Justice, Ian Binney, who is one of the strongest judges of our Supreme Court in its history, I would say. And he said, yes, they were bringing the application for leave to appeal, and he used the term with relish. And I said, well, mustard and ketchup too, I don't know. But, there really is this interest of justice core to what they're talking about. Counsel for Chevron Canada and Chevron US, two separate legal teams, and this case is a lawyer's dream. Those of you who run into a case like this in your career will be endlessly happy for a long time. But I guess only really big players can do it. Although the plaintiffs themselves, I'm not sure. I think Lenzner is doing it at this point on a pro bono or contingency basis.
It's on contingency.
On contingencies. So it's a quarter after now. What I'd like to turn to briefly, could you find that slide on the Hague, and that will give Ron a chance to pick up when we have to take off.
Thank you.
It's after issue 5 or...
Is it this one? No.
I think you passed it.
Did I? It's all right.
So I'd like to bring this back to the international lawmaking platform. The Hague Conference on Private International Law, as most of you know, certainly any of you who've taken Professor Brand's classes, is
Here it is.
in the business of codifying private international law on a global basis. We work together on the Choice of Courts Convention Ron mentioned, and the history of that negotiation really goes back to the limits of my original point in relation to public policy, that it's a narrow defense if it's premised on generally copacetic legal norms between jurisdictions. And that's your common denominator. If the senses of justice from one participating state to another essentially reaches a common point, then you can have treaties like this. And the public policy defense does not have a lot of roles to play. However, what we found in the Choice of Courts project starts around 1994. Ron's out of the starting gate on that, and there's an article he publishes in a Canadian law review the next year. I've got a companion article to it that says, well, this whole system's screwed up. We really do need some kind of common denominator or playing field. And we started out with what the Hague Conference has now returned to, which is two projects. One that's maybe coming to fruition this summer on recognition and enforcement, and another one on jurisdiction. What we ended up with on that 10-year project was both sides of that picture, jurisdiction and recognition and enforcement, but only in relation to contracts between parties in different states who essentially have a clause saying, the courts of one jurisdiction or another should take this, and that becomes the engine for the treaty telling courts of the various jurisdictions involved, what they should do. But what happened over the course of that 10 years was that's what we ended up with, because ultimately a lot of the norms were broadly conformable, like civil law tradition that Professor Curran teaches in this school, and the common law tradition go at things quite differently. It's sort of like René Descartes on the civil side versus Francis Bacon on the other, and deductive versus inductive reasoning for those of you who didn't take a philosophy course. But the devil was in the details, and those details severely conflated the common denominators that we could look at, like the jurisdiction question, the race to what Peter Truboff, who's going to be speaking at the school in April, is going to call the race to the courthouse. And in the civil law system, a lot of civil law systems, there's constitutional norms which say if the basis for jurisdiction are met, then you've got a constitutional obligation to hold on to the case. And the doctrine of forum nonconvenience has no role. On the public policy standpoint, it can get very specific at where this consensus breaks down. I had personal experience with it. To give you an example, while Canada and the U.S. tend to get along reasonably well, notwithstanding the current administration in Washington, I won't go further than that. There are blips, and one of them, an historic one that's been around for the last 40 to 50 years, is U.S. policy in relation to Cuba. An embargo, severe trade sanctions, criminal penalties for quote-unquote trading with the enemy. So a stock public policy case in Canada would be an enforcement of a judgment against a Canadian entity based on civil damages arising out of trade with Cuba, and they want to collect from the Canadian company. That would be a classic case of contrary to Canadian public policy as enacted in the Foreign Extraterritorial Measures Act, which blocks Helms-Burton, which blocks trading with the enemy, and the regulations which the Office of Foreign Asset, OFAC, Office of Foreign Asset Control, police. Classic example. There's the company on the outskirts of Philadelphia. Ballot-Kinwood, I think, is the neighborhood. A company called Perlite. Main operations in the United States, but they have vibrant subsidiaries in Mexico and in Ontario. The Ontario company was doing business with Cuba for water purification systems. There was a dialogue between U.S. and Canadian authorities at that time, and I did a number of these things. It was like papering a file. A letter would come from U.S. head office to, typically, this is a typical scenario, letter would come from U.S. head office to the Ontario head office saying, you cannot do business with Cuba, like just sort of straight like that. And so the Ontario sub would say, they'd consult their lawyer and say, well, what do we do with this? And the Canadian lawyer would say, well, you can't comply with that because if you do, you're committing a criminal offense in Canada. So the letter would go back to head office in the United States. We can't do this because it would constitute a criminal offense in Canada, and so we have a valid defense of compulsion under Canadian law. Leave us alone. And okay, a letter would go into a lawyer's office at state in Washington, and it would go into a lawyer's office at the Department of Justice in Ottawa, and that would be the end of it. This case, a little different. That's where the case ended for a while, but the individual concerned, an unfortunate individual by the name of James Subsali, got a promotion to the head office in Philadelphia. So he moves to Philadelphia, big promotion, big money, and a big present on his desk when he gets there, a 77-count indictment from the U.S. government. And I ended up being a witness for the Canadian compulsion defense in that case. But it was a classic example of the public policy of the two countries just being the complete obverse of one another. That's your clearest case of the public policy defense coming into its own to say we can't go there. But it's a rare occurrence. It's a rare occurrence. Ultimately, I don't think Mr. Sapsali went to jail, although I lost track of the case after we whittled the 77 counts down to 7. Apparently, there was a really ambitious USDA in Philadelphia who was cutting his
Teeth.
cutting his chops on this case, and eventually he was reined in a bit. But hopefully that, and we have 5 minutes to spare before we're whisked out of here. If there's any questions before we have to disappear and Ron takes over to make sense out of anything we've said or not, we welcome them.
Yes, go
I
ahead.
have a question regarding sort of the way Morguard is applied. So in the U.S., we kind of have this idea that a jurisdiction might try to protect their own plaintiff if they're like a citizen of that territory. If a Canadian court sort of gets that idea of a foreign court that the court gave jurisdiction, would they throw out the case, or would they still have to enforce it under Morguard?
Let me see if I understand that. So basically, in every instance, okay, a Canadian court will simply apply the real and substantial connection test, okay? Notwithstanding the history of fairness coming out of the foreign court, right? The independence of the foreign court, that comes later in the impeachment defenses, right? But just strictly looking at the real and substantial connection test, the Canadian court will say, okay, did that court have jurisdiction over the individual and or the subject matter? If it does, then it's fair game. If not, then it shouldn't have continued with the proceeding. Does that answer it? Yeah. It's a very dry look at the case.
In applying the real and substantial connections test, will a Canadian court, look at all of the law of the foreign court? Say if it's a U.S. court, they won't look at the jurisdictional rules at all. They'll just
Nope.
apply the Canadian
No. The Canadian courts will tell you, or will tell the defendant, if the Canadian court determines that the foreign court exercised jurisdiction correctly in terms of the real and substantial connection test, right? Then, it will not look at the foreign law, because then now you're retrying it again, right? And the Canadian courts will not go down that road again unless one of the impeachment defenses come in, right? So, if, for example, the defendant was subject to an action where there was no notice given, right? Or they weren't afforded an opportunity to provide a defense, or they weren't afforded an opportunity to hire their lawyer of their choosing, for example. We're just
Normally would go straight into the impeachment defense, and they wouldn't scrutinize. They certainly wouldn't scrutinize the foreign substantive law. But what they might do, especially if defense counsel in the receiving court is adept and gets evidence in there of what the foreign law is, if it could be shown that the foreign court screwed up under its own rules, then that'd be a legitimate argument on the jurisdiction. Right? If a defendant seeking to block enforcement could say, well, the foreign court didn't apply its own law correctly in asserting jurisdiction over this over this defendant, then we're not going to compound the error. But in the normal course, errors like that would kind of fall into due process. But there's a distinction between applying whatever your jurisdictional rules are correctly versus procedural unfairness or the failure of due process. Like the rule says X, but Y happened and the court missed it. I had one case which was really unfortunate when it came out of Singapore. And the major defense to that enforcement was public policy. And the record showed pretty clearly that the Singapore plaintiffs got most of what they were owed under a breach of contract situation from a parallel arbitration. But then a subsequent proceeding was brought in the Singapore court, which looked a lot like a double recovery, which clearly bankrupted the company, or would bankrupt the company if it was enforced. And I came into it at the application for leave to appeal to the Supreme Court of Canada stage, just doing an affidavit on part of the industry that it was a mining company, that this was just patently unfair and shouldn't stand, and the court should look at it. Application for leave to appeal, or what you call certiorari, was declined. And the Court of Appeal said, well, there's all sorts of allegations of corruption here and stuff which in Canadian law wouldn't stand. But the court was very liberal in saying that, at least while not in criminal cases where people get sentenced to death at a drop of a hat, in commercial cases, they're really quite good. And it's a major commercial center, and we don't see any manifest bases in Singapore law as enacted, right? It's how the law is written to apply the public policy defense to avoid, to block enforcement. And so it went through, and the company went down. So, in the normal course, going back to where we started from, these impeachment defenses, public policy included, are very narrowly defined. And if you don't have the smoking gun, you're not going to make it. You're not going to make it over the hurdle. So comity almost reigns supreme.
Absolutely. Yeah.
We need to make sure you get your flag.
All right.
So,
Thank you very much.
Thank you.
okay, so I'm going to just follow up on that. But let me just say, U.S. law and Canadian law are a lot alike on this, but there's important differences. On the recognition and enforcement of judgments area, we start in the same place. The first question a court asked is, did the foreign court have jurisdiction? Okay, but in the United States, we both asked it the same way. Did they have jurisdiction, not under their own law, but under our law, as we understand it? So in the United States, the question is, did they have jurisdiction under a due process analysis? It doesn't matter what their jurisdictional rules are. Now, Canada asked a similar question, except that they asked, did they have jurisdiction under the real and substantial connection test? Now, note that there's a significant difference between the real and substantial connection test and U.S. due process, and it comes in specific jurisdiction, not in general jurisdiction, because as Scott and Ruspa said, you've got similarities on general jurisdiction. If the defendant is there, and as you know from your own studies in civil procedure, and that the United States Supreme Court has changed that dramatically beginning in 2011, and said, look, if they're at home, if this is where they are, they're one place, okay, for general jurisdiction. But our test for specific jurisdiction is if the defendant had an act or directed at the forum state, and the cause of action arises out of that act. So for the United States, you have to have the state or the jurisdiction, the defendant, and the cause of action. Okay? And the defendant's action in the state, the cause of action must arise out of that. So you've got a three-way nexus. The real and substantial connection test, and the trouble when we try to put it into a kind of global process is not and, it's or. Okay, it's not and it arises out of that act in the forum state. It's, is there a substantial connection between the state and the defendant, or the state and the cause of action? Okay, so theirs is an easier test to meet. That's the starting point. So let me just run through a little bit, and we'll see how much time I have here, because there's a lot here on what I was going to, but just to bring the discussion of recognition of foreign judgments into the global context, all right? We've looked at Canada. If we look at what you're looking at in transnational litigation is private international law, this concept, and three basic issues: jurisdiction, applicable law, and recognition and enforcement of judgments, the kind of pillars of traditional private international law. Now, I tend to believe that private international law and international trade law, particularly when it comes to non-discrimination, come together, and I'll come back to that. Because on recognition of judgments, when you have this global system or the European system for free movement of goods, you can't have free movement of goods, services, and capital unless you have free movement of judgments. So it's a part of the trade law system as well as the private international law system. Now, in the United States, you all know that internally, if you have a New York judgment, you can bring it to Pennsylvania, you get full faith and credit, right? It's a very simple thing. Few words in the Constitution takes care of it, except for some jurisdictional matters. For external judgments, and I'm sure you'll be going over this, or if you haven't already, 1895, the Supreme Court in Hilton versus Guillot said two things. One is we give it a comity analysis, and normally if it's good in the foreign state, it will be good here, except that we apply international law concepts, and we find that international law requires reciprocity. So a French judgment given in favor of a French citizen against a U.S. citizen won't be recognized in the United States, not because of lack of comity, but because lack of reciprocity. Now, that reciprocity element has been pretty much forgotten. The comity has been maintained, but in 1926, the New York Court of Appeals kind of said, well, this is not really a federal common law issue, it's a state matter, and after Erie, all of the states have considered it to be a matter of state law. So recognition of foreign judgments is not a federal law matter in most cases. It is a state law matter. But there's been a lot of discussion on that, and the Uniform Law Commissioner said, not only is it state law matter, we want it to be state statutory law. So they had a Uniform Act in 1962, they revised it in 2005. The restatement third in 86 acknowledged that. The most recent restatement fourth does the same. But at the same time, the American Law Institute has proposed a federal statute to federalize recognition and enforcement of judgments. And if you think of the U.S. Constitution and the control of Congress, Article 1, Section 8, over foreign commerce, clearly there is the power for Congress to do that, but Congress has not done that. In the European Union, there is what was originally a treaty, now a regulation, that deals with, is their full faith and credit clause, deals with the internal recognition and enforcement of judgments. So a French judgment can be taken to Germany, a German judgment can be taken to Greece, and right now they can be taken to the UK until March. For external recognition, and this is where it gets different, you must go to the law of each member state if the judgment comes from the United States or from Canada and you want to take it to be recognized and enforced in Europe. And it's not the same rules that they have internally. And it actually is much more difficult. And different countries have different approaches to it. Germany and Italy are like the United States and Canada. They say, look, if you had jurisdiction under our rules of jurisdiction, you're good, unless there is fraud or lack of due process or violation of public policy. The United Kingdom says, well, no, we can take lots of cases in our courts against foreign defendants, but if you took a case in your court against a foreign defendant, there are only 4 bases of jurisdiction that we will recognize as good if you want to recognize that judgment here. That's discriminatory, clearly discriminatory. They say, we want to reach out further with our jurisdictional rules than we're going to allow you to have reached out if you want to recognize and enforce the judgment. Now, Canada, the United States, Germany, Italy don't discriminate in that way. They say, if you had jurisdiction in a way that we find appropriate for our courts to have jurisdiction, that's all right. People's Republic of China, just the third largest economic unit in the world right now. For the first time in June 2017, recognized and enforced a U.S. judgment. Now, why is that happening? Well, it's all a part of the Belt and Road process in China, where China now has become not just the host country to investment, but now is trying to be the investor all over Africa, Asia, South America, Latin America, and so they want the protections. So they're saying, we will enforce judgments because ultimately they're going to want other countries to recognize and enforce theirs. Now, what's happening on the global level? Scott mentioned the Hague Judgments Project. It was a U.S. proposal in 1992. It was placed on the agenda. We were going to have this big treaty that's going to cover all of the matters of jurisdiction and recognition, enforcement of judgments. We found out we couldn't do it. Okay, so we cut it back. In 2005, we ended up with what I think was really valuable, the Hague Convention on Choice of Court Agreements. The EU, Mexico, Singapore are now, and Montenegro are now all parties to that. Ukraine, the United States, and the People's Republic of China have signed but not ratified. There's a political problem with ratifying. It's the same political problem we have everything in the United States. One group wants to do it by state law, wants to do it by federal law, and so we're at an impasse. But what has happened is work has gone on the judgments recognition process with a draft of a treaty on judgments recognition and a diplomatic conference scheduled for this summer. What does that treaty say? Well, it does it. Article 4 says a judgment given by a court in another contracting state shall be recognized and enforced in accordance with provisions of this chapter. And that takes you to two basic articles. Article 5 has bases for judgment recognition. Now, again, in the United States and Canada, the current basis is your judgment is good if the foreign court had jurisdiction under rules that we acknowledge as valid jurisdiction rules. That's not the way it's done in Europe. And so we're doing it the European way. And so in Article 5, there are 13 bases of jurisdiction that will be recognized as valid, indirect bases, as legitimate. But the problem with that is that there's also this Article 21. It says the interpretation regards shall add to its international character. Those of you who are familiar with the UN Sales Convention, the CISC, know that that provision is in there as well. And what it means is that the ultimate interpretation of the convention, there's no one body to do it. It will be done by every top court in every one of the contracting states. And so what you have is 13 different jurisdictional bases, very complex and convoluted, each to be interpreted by every national court. My own feeling is that will collapse under its own weight. The other problem is you have what I've just described as a jurisdiction gap or discrimination in the United Kingdom. I don't think that it's good. This problem of uniform interpretation is a problem that has to be addressed, and this 13 indirect rules of jurisdiction in Article 5.1 I think are going to be a huge problem. The other problem that hadn't even been touched until you get to diplomatic conferences is what about mutual trust, okay? Are you going to join a convention where you know that every other country can join it and you will be obligated to recognize and enforce the judgments from their courts? That takes us to the end of the class time.
It does.
And that, but so keep an eye on that convention. Take a good look at the Choice of Court Convention because it may well become law in the United States, but keep in mind it all starts with jurisdiction, even though you're dealing with recognition of judgments. Okay.
Thank you so much, Ron.